Hello and welcome to Coproduce Care. Today we have with us the wonderful Belinda Schwehr, and she's going to be talking all about the Care Act easements. So a big topic. But first of all, I have to introduce myself. My name is Sophie Chester-Glynn, and I am the director of Coproduce Care. And for anyone who doesn't know what Coproduce Care is, we're a new non-profit organisation. We started up late last year, and the whole aim was to democratize the care debate. So waffly words, but basically we wanted to widen it so more people knew what social care was. We can understand health a bit more, and we're blogging, vlogging and interviewing people about health and social care. So if you haven't subscribed to our YouTube yet, then do press on the subscribe button, click on the bell, because we're going to be doing a series of live interviews, live streams. And the plan is to get as many people on as possible. We had no idea that COVID was going to happen when we started up Coproduce Care, but I think we're going to use our platform to just get those voices out there and hear more about the important parts of health and social care. So a few technical bits to talk about, really. We are brand new to the live stream. We did a test one last night, which you can view on our YouTube channel as well. And we talked about the care sector locally. And we've got a few coming up next week. We're going to have Belinda on again. After that, we're going to be having other guests from Skills for Care, other people, parents of people with autism, and lots more. So do check in with us and follow us. But I'm not going to spend too much time introducing us. Safe to say that we want as many people to tune into this as possible. So do let us know if you can't hear me, then shout out in the comments. If you can't see us properly, then do make a comment, and we've got people in the background that are helping us out with the tech. But also, can you share this? Even if you're listening to it live, click on share on Twitter, and share as much as you can so that we can get as many people into this. So thank you for joining, everyone. I'm delighted to have Belinda on. It was only 2 weeks ago, I think, not even that we discussed talking about the Care Act easements, and now it's a hot topic. So I'm going to just introduce Belinda now. So hello, Belinda.
Hello. Hi, Soph.
Hello, thank you for coming on. And it's fantastic to have you on, and you're CEO of CASCAIDr, which is a fantastic organization that supports people, that advocates for people's rights. We've also done a podcast before on the Care Act, which is fantastic for people to go and listen to. But of course, you are a charity, and these are hard times. So I will say that, you know, if people can donate to CASCAIDr, you'll hear from Belinda and you'll hear the wonderful stuff that she's doing. I've donated earlier this week because I'm a big fan. So the details are in the description of this video. I know some people are also tuning in on Facebook, so same details there as well. And we'll put them in the chat function. So Belinda, can you introduce yourself a little bit more and tell us what you're going to be talking about today?
Okie doke. My name's Belinda Schwehr, rhymes with care on a good day. And I've been lecturing for 20 years. From having been a lawyer originally, I've been training social services staff to do the care functions as legally as is humanly possible. When the Care Act came in 2015, we trained 40 councils in a very aspirational piece of legislation that was all about personalising care, all about ensuring that people were kept at the centre of what it was all supposed to be about. But it carried forward about 15 years worth of community care law, which had given people with disabilities and older people some actual solid legal rights stemming from the legal duties that were in the Care Act. And that's really what the Care Act easements are all about. The Care Act has been thinned out by dint of the coronavirus. And why that's happened is quite interesting. But we in the charity think that it's very important that people know what it actually means and why they should ask their local authorities whether their councils have adopted the easements or not. So far as I know, I think 8 councils have gone into an easements phase, and that means that they're not operating under the Care Act as it was originally known and loved by some of us, at least.
Great. So I've got a few tweets that came out 24th, I think, of this month last week, and it was all kicking off because people were talking about the easements and saying, you know, there's a few local authorities who have enacted them. I've got a few tweets here. People were really concerned. They were thinking, you know, what does this mean for us? How is it going to change what we are actually entitled to, or how we can support the people that we support? And then the Law Gazette also published something which I'm not sure is available anymore, but we've got a snapshot of it there. So yes, you were, when you actually saw this, you thought this is exactly what you were worried about.
Yes, I've just seen a comment from somebody that says, balefully but correctly, in my view, no council was operating according to the Care Act anyway. And I think that's a really good point, because everyone knows there's been 10 years of austerity, and it's meant that in the last 5 years, there's been very little judicial review of the way local authorities were actually delivering on the Care Act. It was all happening through complaints to the Ombudsman. And I had just about got to the stage of thinking that the Ombudsman was a good substitute for a public law challenge, and of course free to members of the public, when the virus came along. And within about 2 weeks of the beginning of March, the legislation had been put on the statute book, and the easements became available to local authorities as of the 1st of April. So I think we'd better explain what they are, because easement sounds just such a friendly, lovely word, instead of really being about the Care Act light. The easements are a polite way of saying that lots of statutory duties are no longer in place. And so I think I better explain to people what the Care Act even gave them.
Yeah.
It's not fashionable in social care to even admit that law matters, in my experience, but the Care Act gave people enforceable absolute rights to have their needs, their assessed eligible needs, met, and met appropriately, if they only knew how to get an advocate or to how to say that themselves. So the most incredible thing that the Care Act easements have done is to suspend the duty to meet needs, unless it would be a breach of human rights to fail to do so. And the concept of a breach of human rights is actually very hard to prove, because you have to have an extremely bad piece of decision making or a scenario to get that far. But it's not just that. It's the duties around getting into the system that have been changed. So the duties to assess on the basis of an appearance of need, the duties to keep people under scheduled regular review, and the duties to actually record the care plan halfway transparently. All of those duties have been suspended. The very bizarre thing, though, is that although that is the law now, councils have been told by central government not to operate under that view of the law unless they absolutely have no choice because of local circumstances but to move to the easements. And that's a very novel thing for a government to do, to pass legislation that is effective for local authorities and then say through guidance, but please don't do it until you absolutely have to. One of the problems that brings in, of course, is that it makes it all incredibly obscure and localized, so that there's no national threshold any longer, even though councils did interpret it differently. It means that it's a real lottery. And unless people ask and are told the truth about whether their council has moved to the easements, they would be up a gum tree, because they would be in the fog about whether they had the rights or whether they were on a wing and a prayer. I don't mean to be alarmist about it, and I'm going to be saying, if I get the chance, that it's not the end of the world, but it is a serious change to the social care safety net, I have to say.
So you talked to me before about these light touch versions. So, how would anybody know whether the council has taken up a lighter version of the Care Act than the full one? How would people, you said it's really important that people are told that this is happening, but how would they be notified? Is it just, something on their website, or would local authorities be sending out information?
The easements guidance to local authorities instructs local authorities to announce it, to notify the Department of Health and Social Care with a set of, I won't say justifications, but a set of facts and statistics that have gone to influence the local authority in deciding to use the easements. And everybody assumed that that list would be public. But as it happens, it hasn't been made public. And so this is why social media is abuzz with whether people have done it or not. So there's Solihull and Birmingham and Coventry, Derbyshire, Staffs, Warwickshire, and Sunderland and Middlesbrough, who are known already to have moved to the easements. We at CASCAIDr have FOI'd, freedom of information, all councils to find that out. And we are getting some answers back, but some councils have actually suspended FOI as well. So it's very frustrating. We had hoped that the Department of Health and Social Care would respond to questions in the Lords debate last week and in the Commons yesterday and move to publicising it. But I don't think that that's been done at the moment. So the most obvious thing is that a council would put it on their website. Most councils have got a COVID pop-up, and you would expect, therefore, to be able to know at once whether your council is at stage 1, stage 2, stage 3, or stage 4. Stages 1 and 2 are this side of the Care Act line, i.e. the good times, and then stages 3 and 4 are over the line, operating the Care Act as it is now amended in legislation, i.e. one has moved to the easements. So that's really what the situation is about public knowledge.
Just a very quick question before I ask another one. Someone asked, does CQC have a place in notifying people about, when people are using the easements?
No, it doesn't. CQC's role is still focused on providers rather than on assessors and commissioners and reviewers and funders. So you won't find that out from CQC.
Okay, that's helpful. Thank you. So can you give an example of what would be said about getting assessed under the easements compared to what the law normally requires?
Well, this is interesting because it brings up the point that one of your attendees made, that lots of councils haven't been operating properly under the Care Act anyway. But let's put it this way. In the good times, a council might, for instance, signpost people who want an assessment out to the voluntary sector, first of all, for the big society view of things, all of those community-based assets, things that charities offer, self-help networks, etc. Another thing a council might do to kind of stem the flow inwards is to turn on reablement services, which are free for 6 weeks. And they would pause the assessment until that reablement had an effect on the person and reduce the needs down. Another good but legal wheeze in the good times is to persuade better off people, financially better off people who've come for an assessment, that there's no real point in coming through the council because the person would be charged full cost for their services anyway. And therefore, wouldn't they prefer to just go out and buy services from the private sector and just get on with having had the benefit of a professional's view as to what they need, but go out and do their shopping themselves. There's all sorts of things that they might be doing in the good times. But now, what you're likely to see if a council has moved to the easements is that they haven't got some of those options because, for instance, community services are all shut because of the lockdown. Reablement and even full-on home care services may be very short-staffed, so councils wouldn't be wanting to switch those on in the normal way that they would. So my thinking is that even financially well-off people can't just be signposted to go out and buy their own services, because those services may also be shut and literally at capacity. So what I'm thinking that councils might be doing if they've adopted the easements is saying that they're very sorry, but there's a waiting list for assessment, for instance, or that they're screening people for urgency as to who even needs to be assessed in the first place. Lots of other councils will be streamlining their forms and maybe cutting 3 conversations down to 1. And some councils will be allowing online supported self-assessment and just trusting people to tell them the truth. So our concern about that is that there's scope for arbitrariness. There's scope for people to be assessed in an out-of-line way from how they normally would be. And if you think about a waiting list, it only takes a moment's thought, I think, to figure out that the way it is structured is the key thing. Because if, for instance, it's by reference to alphabetical order of people's names, well, that's a crazy way to be running a waiting list when the whole statutory context is the meeting of needs and very extreme needs in these particular circumstances.
I mean, so you'd hope
one needs to ask and then think, does that make sense? And if it doesn't, you need to push a bit further.
That's really helpful, Belinda. I mean, you'd automatically think, well, I'd hope that the most serious cases would get priority. And I think, you know, I run care provider service for people with learning disabilities and mental health in another life. And, you know, you are often told that's how things are done. So you'd hope that's the case. But another question really is, you know, what do the easements mean for actually getting a care package in the first place that's, you know, good enough, that's person-centered, and that meets people's needs? Presumably a person-centered care is, you know, something that still needs to be maintained. I mean, there's the well-being principle within the Care Act. So you'd hope that would still continue.
Yes, that hasn't changed at all. The well-being principle is still there, but the way that operated was through the duty to assess and through the duties to involve people's relatives and through the duties to come to a sufficient and transparent, sized and filled up care plan. So now, if you get the miracle of an assessment, you've then got to operate on the basis that there's no duty to meet your needs unless it would be a breach of human rights. And that would actually, if councils were doing that, mean that hardly anybody got a care package. So clearly that's not what can happen. And what people need to understand is that local authorities will be running care planning through the medium of a power to meet needs rather than a duty. And a power is a thing that operates on the basis of people's discretion and judgment. And a power is harder to judicially review than a duty is. And this is the moment where I want people to understand it doesn't mean it's impossible to challenge, but it makes it harder. So, for instance, if a council had an arbitrary approach to everybody over 65 or everybody with a learning disability or everybody with autism, then on that footing, they could still easily be judicially reviewed. But if, for instance, they want to say, well, in this case, because your situation is this, this, and this, then we think that we can either take something from your care plan, or we can say that such and such an amount of this, that, or the other will have to do because of everybody else's interests. The chances are the courts are going to be sympathetic to the very grave difficulties that councils will be having, spreading the resources ever more thinly. Ironically, it's always been about money before, because the money was getting smaller and smaller from central government. But now the issue is actual bodies to do the care, because half of the workforce may be self-isolating or sick or off or shielding. And that's just not just true for local authorities' social work staff, but it's true for key workers as well. So the thing you have to understand is that it's the inherent volatility and instability of the job of allocating stuff to people that councils have got to grapple with at the moment. And that's why they've been given permission to prioritise, but it doesn't mean that they're not challengeable if they make ridiculous decisions. If I could just give you an example, somebody rang me up today and said this. They said, our direct payment for our son used to be £16 an hour. And we've just had a letter saying that the direct payment that we use to pay our workers for our son has been put down to £10.75 an hour. Can the council actually do that? And I choked a bit, because the one thing you can guarantee in the COVID pandemic is that the scarcity of labour is putting prices up and not down. So for the local authority to ignore market forces and think that they can just change the direct payment rate and put it down £5 or so is utterly unbelievable to somebody who has been training councils for 20 years. I just, I am speechless at that kind of arbitrariness, and that should not go unchecked. And why do you view that you have to do?
100%. I mean, that's just shocking, and I don't know, why they would do that in terms of, is there a justification for it, or do they just notify that person?
First and foremost, people have to understand that you can't change somebody's care package without doing a proper revision exercise. Section 27(2) of the Care Act has not been touched by the coronavirus legislation. So an existing care plan cannot just be changed by managerial edict. And putting the rate down to £10.75 in a letter which effectively changes everybody's care plan significantly, not in relation to the needs or the hours of care that are needed, but in relation to the budget. That is one of the most classic mistakes any council could make. There's case law that is 20 years old on not being able to do it that way, and the Care Act has not been amended and requires involvement of the service user and the carer and anyone else that the person wants to be involved before it can be changed. So, that is breathtaking to me.
That's actually a really good point that you make, Belinda. Even if a care plan needs to be changed, you still need to, even under COVID, you still need to consult the person, which seems like a no-brainer. But sometimes I hear language, whether it's in meetings or in the media, usually it's what we're going to do to people who are being cared for. We're going to move older people here, or we're going to, put people in certain places. No one really comes with a rhetoric which says, once we've consulted with the person who is potentially at risk or sick, then we're going to talk about these options, which may be X, Y, and Z. So it's good for you to say, actually, people need to keep in mind this need to consult with the person that we're looking after.
Yeah, the magic word is involve. And I think it's an interesting woolly word. For instance, the parent of a person with learning disabilities would automatically assume that they would be present at every meeting. But involvement doesn't go that far. And you've mentioned the word consult. And consult is a common thing in the mental capacity legislation. People's best interest consultees expect to be consulted. And involvement is not the same as consultation. So it's been put into the Care Act, unfortunately left there, but it is deliberately ambiguous in the first place, because it isn't clear what the minimum involvement could be that would actually pass muster as involvement. But one thing I absolutely agree with, it doesn't mean being told after the fact what is to happen to you. So that much is absolutely clear, and that's not been changed at all by COVID.
Okay, I'm just going to give a quick reminder to everyone that if you're finding this useful, if you think other people need to hear it, then please share. Don't forget there's the donate as well to CASCAIDr. And if you're looking to find their logo anywhere, I'll pop it up here if you see it. But there's details to their website, which we will have at the bottom of this screen at any time. But do subscribe to this channel and the usual jazz and all that. Yeah. But anyway, that's boring. Let's get back to the good stuff.
Can I just say something? I've noticed some of the comments that have been, and I really have to take TLAP to task, because TLAP is saying that co-produce is the word rather than consult or involve. And in fact, the word co-produce is nowhere in the Care Act. It is in the guidance, but there is not even a duty to share care planning with any member of the public. Co-production is extremely ethically sound and is the way everybody should be going. But in the Mental Capacity Act, the word is consult. And in the Care Act, in Section 9 and in Section 27(2), the word is involve. I promise you.
Really good point. At first, I was a bit scared when you thought you were going to start a little bit of a dispute, and you might do on the chat. But yeah, I think that is the point. That's why, I think co-production is absolutely where we should go. I learned about the whole word, the concept from Sky, and TLAP have inspired me a lot, and I was glad to see that it was in the guidance. But the guidance is just, people have to have due regard to the guidance, if that is that right, there's the right legal wording, but it's the act that people really need to follow, and it's not in there, which is really unfortunate. And maybe that's something that we all need to work hard on, to get people to understand what it is, and trying to lobby for people to do it, because it is such a different way of thinking about what we're doing in care. It's like a cultural change, really.
Yes. Can I say, anyway, I think that it is much better for people to know what the truth is about their legal rights than the rhetoric. And I mean, people might say to me, is this the easements? Is this the end of personalisation? And I would absolutely say it isn't, because the Care Act easements guidance, which they do have to have regard to, and which they may even be directed to follow if everybody goes native, that Care Act easements guidance itself refers everybody to TLAP I statements and insists that everybody still should have a personalised, person-centred process. The trouble is that you've got 150 councils all on a different stage of that journey to thinking really differently about how to interpret the legislation. In a really strange way, COVID could save personalisation from austerity and everybody's reluctance to speak truth to power, because in an ironic way, the focus on the ethical principles and the focus on human rights takes us back to the time when that was all we had: ethics and principles and social work values and human rights and public law. And I, for one, do not think that there was anything wrong with that. The era in which everybody was told they could do anything they liked with a direct payment, so long as they didn't exceed the budget, gave people the wrong idea about the amount of flexibility that they could even legally hope to get. And so I don't want to make it a rant about the difference between rhetoric and reality. Now we've got another layer of obscurity, because we've got councils perhaps going back towards fair access to care services, notions of critical risk to independence, which they could do, or they may go back even further. When I started out being interested in this field in the 1990s, I promise you there were councils who had matrices by which they did risk assessment. And the test was, how many times have you fallen over in the past 6 months? That was the way social work values were translated into a care package. Nothing like a resource allocation system, and nothing like supported self-assessment or any notion of co-production. But involvement and participation are fundamentally public law and human rights values. I'm not recommending everybody gets litigious, but I think it's better that people know that they've got legal rights.
Yeah, absolutely. I think it's a really, really good point. And there was a question, just a slight technical type of question earlier on, about whether these apply to children's services. If I read rightly somewhere, if I could find it again.
I'm an adult services lawyer. Changes have been made to children's services, and people like Steve Broach are following those. He's a barrister. There's another barrister called Dr. Oliver Lewis. And SEND lawyers, special education lawyers, are covering those things. But my interest is adult services. I was going to say I don't touch children with a barge pole, but that probably isn't an appropriate thing to say.
No, maybe not children, but you are a big fan of birds. I can hear them in the background. I should have probably said that at the beginning. Your budgerigars making a cameo.
It's not personal budgets here, it's personal budgets. And yeah, I can't stop them. They're obsessed with the Care Act, I'm afraid. So
okay. Yeah. Right. So what I was wondering is, what if there literally is nothing available to somebody? Does that make it legal for a council to say no to organising something?
That's an interesting question. And I think that we're being told that we're not at that stage where there is literally not enough of something, certainly in the NHS. But let's put it this way. If in the normal era, a council could not buy something because nobody would sell them it, then the council would have to meet the needs themselves. That's the whole point of a statutory duty. So the law is that in the good times, if something is needed and it's the only way of meeting a need, then it must be paid for regardless of the cost. And that's an extraordinarily powerful legal right, except that it's not often, of course, that there's only one way of meeting a need. Now, imagine a scenario where it's not about price. It might still be about price, and that's very hard to figure out with commissioners. But let's suppose that during COVID, we've got a situation where it's not about price. It's about the literal non-existence of a necessary service. I don't think that a judge would find a council to be in breach of human rights if it could at least show it had used its best endeavours to find some way of meeting that need. And I say that because judges are not daft. They can't click their fingers and magic up an empty bed of a specialist nature, for instance. They can't click their fingers and make a landlord give a tenancy to somebody for supported living if that landlord doesn't want to take the risk. So my point is that there may be an argument that to go without puts the council in breach of human rights. But for instance, unless the standard of that person's ghastly situation is really, really intensely awful, a judge is not going to find that it's a breach of Article 3. That's the prohibition on inhuman and degrading treatment. A judge is going to say that there was no intention, for instance, to degrade or demean or treat the person as if they were being tortured. It's not the council's fault that there is literally nothing with which to meet the need. And the most other obvious human right that's often in play is Article 8. That's the right to respect for people's private lives and their homes and their families. So from that perspective, you'd think, well, leaving somebody without services or expecting their family member to do everything for them just because they're at home on furlough, you would expect that you've got a runner of an argument there. But in fact, Article 8 has got caveats and qualifications in it that actually invite local authorities to weigh up the interests of one person against the interests of the wider community, for the protection of other people's health or morals, for instance. So I'm really trying to say, I think, that if there is something that's needed that is literally unavailable, I think a judge would be very sympathetic to a challenger, but not ultimately grant a remedy. There is one thing I think that council should remember to do, though, before they just throw up their hands and say that it can't be done, because anyone who is in need could be given a direct payment, and then their relatives could be given permission to be paid to meet the needs out of that person's direct payment. That is not normally allowed. But when they created the Care Act, they had the good sense to put in it an exceptional situation for asking the council to deem it to be necessary that somebody's close relative in the same household should be given permission to be paid. And until a council has rationally weighed up the pros and cons of meeting the need through that unusual arrangement, or not meeting the need at all and being judicially reviewed for a breach of human rights, I think you can probably see it might make all the difference. It might solve the local authorities' financial problems, and it might free up other agency employees to go and serve somebody else's needs. So I'm hearing that lots of councils are allowing that to happen, which is refreshing and good.
So, I mean, we were talking before about family members and helping. Does that come under the issue around direct payment holders, and whether they are being encouraged now to sort of ask their relatives to help out more than they would have before?
Yes, direct payments are the cash in your hand that the council would otherwise spend, but it's the cash in your hand to go out and buy in services yourself. And there's a rule that relatives in the same household, if they're on a particular list of close relatives, are not normally allowed to earn a living from the direct payment. So as I said, there is the discretion to change that position. What you've got at the moment is a lot of people have got relatives at home on furlough, and they wouldn't normally be at home.
Right.
And so because they're at home, some people's relatives are being honest and decent enough to ring up the council and say, we don't need the budget at this minute, because not only are we at home, we're on furlough, and we are willing to meet the needs. In fact, we'd prefer to, because we know that we've self-isolated and our loved one is particularly clinically vulnerable. So we think it would be much better if we met the needs. Now, that is a great position to be in if you're lucky enough to have that. But that doesn't mean to say that a council can say to you when they come to assess you, have you got a relative at home? Well, that's all right then, they will meet your needs. Because the one thing the council cannot do is make one adult look after another adult. There is a law in this country, or rather there's an absence of any obligation to do that. And it's a really good law for public policy reasons. You know, where would we be if we made unwilling carers feel that they absolutely had to meet the needs of their loved ones? One of my fears about what's going to happen after COVID is that the government says the solution to social care is that everybody's relatives should be the first place they look for care. I think that that's got massive implications for equality between the sexes. And I think it's got massive implications for what we expect to educate people for. I've got nothing against a person wanting to be a carer, but I have everything against a person being made to become their intimate partner's personal carer just because they're there.
Yeah, I mean, that is hit on a point for me. I think we could do a whole chat on, from a feminist perspective, or the effect of care and caring duties on women. There's a fantastic book that I read about autonomy, and the name has gone from me. But it really talks about the issue of unpaid or unvalued, or even, as some politicians would say, low-skilled work. And that being valued and seen for what it really is. And I think maybe there's definitely a discussion to be had about going forward about that. Okay. I know one thing I didn't say at the beginning of the chat was that our Thursday night chats are called Chat for Care. So hashtag Chat for Care, and we've obviously tried to kind of rhyme that with Clap for Carers, which is in 20 minutes time, and we promise that we will finish before then. And my son's made a little thing for me to jingle at 8 o'clock. So we've got a couple things that I want to ask, and if you have any questions for Belinda, I'm going to go back to the comments while she talks on the next question, then do start to type them in, and we'll try and keep an eye on those. So I suppose, kind of connected to what we've been talking to about before, is, do you think that the existing care plans that are being thinned out at this point, is that too early to say, or is it too pessimistic, so as to redistribute some of the resources to other people?
I think anyone who's ever been put through a review when they didn't want to be reviewed because they feared a cut will know that local authorities can make cuts to care plans even under the Care Act in the good times. It's always been possible to make cuts to people's care plans for a number of legal reasons, but it's never been done in the context of COVID. So I think here, if people are being told that they need to give up something for the good of other people, I think the vast majority of people would accept that they have some priorities for their own needs. And they may not be the same as the council's priorities, but at least they could order their needs in a set of importance and points for them. And I think most people would accept that in the public interest, rather than have people simply told, no, we can't meet your needs, I think the majority of people would understand and even go along with the idea that they could do with a little bit less for the good of other people, but temporarily. And I think that the danger is that once a care plan has been cut, it may stay cut for much longer than lockdown. And then people will lose their benchmark for why the service was cut. And it will be hard to restore care packages to the size that they once were. But I mean, that's another question about how long lockdown is going to last and how long COVID versions of the Care Act are going to last. What I'm really concerned about is that the cuts that might be made must be made rationally, fairly, and transparently, and definitely not go below the level of breaching a person's human rights. So that's really a very sensitive management task. When reviews have been done in the past, I think council staff have been told to choose the highest cost care packages and work on them. And ironically, I think that would be completely wrong now. I think that the way to order the question of whose services you might cut would be to look to see which are the most inherently likely unstable care packages in terms of the age of informal carers or the dependency on a large number of people to meet the needs. And then say to those people, we are not coming for your care package, because that would materially assist people to cope with the stress of wondering whether their care package was going to be up for grabs. But if any council is wielding a scalpel, then they must wield it sensitively, and they must wield it in compliance with human rights and in accordance with all public law principles. And I hope that that is some comfort to people who think that, you know, there's nothing that they could do or say about it if it happened to them. Any other questions?
Yeah, I suppose lastly, it's kind of to think about, we're in a crisis. You know, a lot of us don't want to be thinking about legalese stuff and really using legal principles right now. We're just all trying to survive. Can we really hope to use legal principles in the middle of a lockdown to challenge a decision if the council behaves, you know, quite badly, if someone believes that that's what's happening over this question?
It's another strange thing, I think, that is one of the ironies of COVID. For the last 5 years, there hasn't been much litigation under the Care Act. And that's partly been because nobody who is a lawyer could really make a living from doing it. And so legal aid lawyers turned their focus to the Court of Protection and the Mental Capacity Act, and it was easier to get legal aid to stand up for people in that forum. Public law, judicial review, happens in the Administrative Law Court, and it has been the devil's own job to get legal advice, because legal aid firms that were still in that market were spread very, very thinly, and often their staff only had a quota of legal aid work that they could do. And that's all part of the history of why CASCAIDr was founded and brought into existence. Well, now, because of the reference to human rights, and perhaps because it's harder to get work, generally, if you're a lawyer, there is a real flourishing of interest in giving or selling legal advice to members of the public about community care. So ironically, it's easier to get advice now than it has ever been. Legal aid law firms abound around the country. They don't abound, but at least their doors are open. And most people on benefits and most people with some form of disability would qualify at least for legal help, which is the preliminary form of legal aid, which enables you to get a lawyer to write a snotty, stroppy letter to a local authority pointing out what they have done that is in breach of the Care Act or in breach of the easements. Also, of course, charities are busy with their fact sheets and their helplines, and as indeed we are. We are still giving advice for free, but we can only, in COVID conditions, finance a quick steer. We like to think it's a correct steer, and it would enable people to take the information back to the local authority and say, hang on a minute, are you really saying that you're going to cut my care plan or not meet my needs? Normally, people would be told to just use the complaint system. But CASCAIDr's view is that during COVID, the complaint system is not fit for purpose within a local authority when you think about the significance of some of the issues that could be playing out. So the guidance, the easements guidance, and we and lots of other people say that councils should make very clear the route for escalation of concerns about legality. And for the first time in guidance, the role of the principal social worker has been mentioned, because each council's principal social worker is the repository of a good many years of social work values-led experience and professional judgment. So a route for challenge could be asking for a management review up through the ranks, as it were, to the principal social worker and the director of adult services to save the council from embarrassment. And the embarrassment would be if they don't think again and give reasons for their position, then the client goes off to a law firm and actually gets a legal advice service at this very difficult time. And so that's another reason why COVID might save social care law, if I'm not too idealistic to think that that could happen.
You're very hopeful. Let's see. We need to do this again in like a 6 months' time and see where we are. While people are thinking of questions, we've got maybe 5 minutes or so to go over some questions. Can I just ask? I think we have maybe 160 odd people watching, and only about 60 or so, or maybe less likes. It costs you nothing if you could just press the like button, whether you're on Facebook or on YouTube. That would mean heaps to us. And obviously, if you want to see Belinda again, she'll be here next week on Wednesday. We'll talk about that in the last minute or so. So one question.
Could I say, I've just seen, and my eye can go up and down the questions, but I've just seen a reference to a question about whether any other parts of the Care Act have been left in place. And I want to stress advocacy. Care Act advocacy is still a legal duty. It's a duty to provide a Care Act advocate in the context of an assessment or a revision or a care planning exercise, and also in case of safeguarding. So Care Act advocates are part of the legal underpinning of any decision that a council makes, even during the easements. And so they should not be forgotten. But they would need to understand the easements, and that means understanding public law.
Okay, thanks for that. I don't know if there's a couple of questions. You can either pick one out again. I noticed one about direct payments. Can people with a direct payment use their existing budgets in other ways if the normal thing they do with the money is not available under the easement? The
direct payment guidance that's only just come out from the Department of Health admits of the possibility that you may need more flexibility than you have hitherto been given to understand that you can exercise. So it says that, of course, you should be in contact with your social worker about needing to make variations to your care plan if what you would normally spend the payment on just isn't there to be bought. But it does really admit of the possibility that you might make that change for up to 4 weeks in an emergency, and that should be allowed by local authorities. So that's the closest the government has come to telling local authorities to get real and let people solve their own problems if they can think of how to do it. So they might spend it on technology if their normal outreach service, for instance, is unavailable. That's the kind of common sense thing that has been embraced by the most recent guidance, yes.
And probably the last question now, and it's come up a couple of times, maybe by the same person, but how would you spot a human rights breach? What does it feel like when your human rights are being breached? It's a good question.
Yeah, you would have to understand what the article was that you were concerned about. So might it be Article 2, which is a right to life? Is it inhuman and degrading treatment? Is it the right to liberty? Is it the right to respect for your private and family life? And you can do that from going on the British Institute of Human Rights website. That they will tell you, they'll give you examples of what has been found to be a breach of human rights. Disregarding dignity, for instance, if it's just for one night, wouldn't be a breach of human rights. But if it was for a year, it would be. And then you've got the question, well, what does dignity require? And we all remember the Elaine MacDonald case where the not incontinent lady was told she'd have to make do with incontinence pads. So there is no easy answer, and I can't give it just like that. But there have been 6 cases in the last 6 weeks mentioning human rights in the context of adult social care and health, about visiting bans, for instance, about treatment for a person who was likely to deteriorate and for whom ICU treatment would be very, very savage, possibly intolerable. There's been a case about evicting a person with a personality disorder and other complicated situations from a hospital bed, and that was not found to be a breach of human rights. So I don't want to end on a downer, as it were, but I do think people need to understand it's a very low level of quality of life that can be allowed without being a breach of human rights. Give me something good to say, Sophie, so I don't have to end up.
I know. I would love to. I just put up the link and the website to the British Institute of Human Rights, which you just mentioned. So that's also in the chat for people. I'm afraid we're out of time pretty much. I mean, I'll say a couple of words and then Belinda, I'll hand over to you. But if anyone in the last few moments, you can just click on the like button. I'm sorry, I'm going to go on about it again. Don't forget, if you're interested in CASCAIDr and you want to donate or you want to know more, there's more information in the description box and in the chat. We will be seeing Belinda again on Wednesday, and I will ask her to give a couple of minutes or a minute or so just to explain what will be going on about on Wednesday, which is again very topical. But yes, please do spread the word, tell people that this is going on Wednesday with Belinda. On Thursday we have a deputy mayor. But do click on and subscribe to Coproduce Care, our website. You can follow us there and learn more about us. So Belinda, next Wednesday, what will you be talking about? You'll be back again.
Yes, I could talk for England given the chance on it. I'm going to be looking at hospital deaths, care home deaths, DNA CPR forms, the whole question of why is it perhaps that people in older persons' care homes have not been finding it so easy to get to hospital, and the invidious question, the human rights question of how would we ration access to a ventilator or an ICU bed. Really controversial stuff, but I'll be putting it in the context of human rights and NHS law. The last thing I'd like to say is I'd really be grateful if people would donate, because the only way we can keep stuff of this detail coming is if we still have some finance coming in. Normally, we would charge people for difficult advice. We don't charge for straightforward advice, but we charge for difficult advice. But I can't bear to charge anybody at this moment for telling them that the Care Act doesn't give them any legal rights any longer. So our model at the moment is that we're just giving people a quick steer for free, and I'm concentrating on pouring out this sort of stuff to the wider public. So our donation button is available, and if you would click on it either now or after the clap, that would be fantastic. Whether you've liked this or not, I hope that you can tell that our aim is true and that we're absolutely coming from a rights-based perspective. So thank you very much. And thank you for Sophie for the opportunity. Okay.
Thank you. We'll see you all soon. Take care. Yeah. Let's go out there and clap for our carers.
Okay. Bye.
Bye.